Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we have picked up some of the important articles which are very significant from your UPSC and your KPSC examination point of view. Let's get started and look into the first article. The first article says Haryana quashes High Court quashes Haryana 75% local quota in the private sector. Let us try and understand what is this article in greater detail. We have the state of Haryana. The state of Haryana had come up with a law called as the Haryana State Employment of Local Candidates Act of 2020. What was this act all about? The act basically said that if there is a private company, this private company will have to employ only locals of the state of Haryana, which basically means if I am from the state of Maharashtra, or I am from the state of, let's say, Uttar Pradesh or any other state for that matter, I would fall only in the 25% bracket, but the rest of the people who are working in the segment of the private sector will be from the state of Haryana in the salary zone which is less than 30,000. So in case there is a private company, the private company is paying an employee a salary of less than 30,000. In that particular case, 75% of the employees of that particular company should be from the state of Haryana, said this Haryana State Employment of the Local Candidates Act of 2020. So who is this local candidate? A local candidate in the state of Haryana would basically be that person who's lived in the state of Haryana for more than 5 years. So any person who's lived in the state of Haryana for more than 5 years, he is the resident of the state of Haryana. Such person will be entitled to seek a job under this Haryana State Employment of the Local Candidates Act of 2020. So what would happen? There would be a portal that would be created. And in this portal, if let's say I am a person who is a local citizen or a local resident of the state of Haryana, what should I do? I am looking for a job. My pay scale is less than 30,000 in a private company. So what should I do? I should prepare my resume. I should tell what are the skill set that I have, and given this details on the portal that is designed by the state government of Haryana. So whenever I am making such a request and I am uploading certain documents and I am asking a private company to employ me, the private company, if I am meeting the skill set that is intended, in that case they have to employ me. So who is a resident of Haryana? Any person who is lived in Haryana for greater than 5 years will become the local candidate, will become the local resident, and I should be employed in that particular private company. And it is mandatory for the private employers in the state to reserve 75% of the jobs paying less than 30,000 a month for the local residents. So only local residents will be able to fit into the job, and only 25% will be for the outsiders. Who are the outsiders? In case I do not have the resident certificate in the state of Haryana, I have not lived in the state of Haryana for more than 5 years, in that case only 25% will be filled by the people from outside the state. So as and when there is an opening that is present in a particular company, that particular company will only have to employ the locals, which is about 75%. The 25% can be filled in by the people from some other states. So employers have also been directed to file quarterly reports on the digital portal, updating with the details of the local residents recruited and appointed. As we initially discussed, there would be a portal. So in this particular portal, there will be all the companies that will be present. Let's say for example company A, then you have company B, then you also have company C as well. So now there is a candidate who is wanting to enter into company A. So he will upload his resume and he'll also put up his skill set as well. After he puts up his skill set, if the company feels that this person fits into that particular job role, they have to recruit. So 75% will be from the locals and the rest 25% will be from outside the state. In case they are not fulfilling this criteria by that private company, then failure to provide 75% of the new employment to the local candidates will attract a fine between 50,000 and 2 lakh rupees, with an additional penalty of 1,000 for each day till the contravention continues. So 75% of the employment needs to be provided by a private company to the local residents in that particular area. This was an act that was passed by the Haryana government. However, this particular act was looked into by the Haryana High Court, and basically now they have gone on to say that this entire act is unconstitutional and has quashed the entire act as well. What were the arguments given by the government and what were the arguments ultimately concluded by the High Court? When it comes to the government, what did the government say? The government said that as of now there is a large scale unemployment crisis in the state of Haryana. Since there is unemployment crisis in the state of Haryana, what is that I have to do? As a state, we have to ensure that people are provided the employment. We are doing everything that is possible from our side on the state front so that these people are employed, and as a result we have come up with this particular legislation. When there are people who are coming from outside the state, there are many people who are coming from outside the state, and as a result people from within the state are not getting the jobs. So what is it I am supposed to do? I as a state, people have elected me, I have a responsibility towards the people of my own state, and as a result what do? I come up with this particular legislation so that they are provided employment means and opportunities. And at the same time, when they are provided the means and the opportunities, I am also providing them the source of livelihood as well. As of now, they do not have any source of livelihood, and as a result, they are facing a lot of problems. So to provide them the livelihood, I had to take this mechanism. I as an elected government, people have elected me, people have ensured that I would be able to provide the means and mechanisms for them to live, which is why I have taken this initiative, said the state government when it comes to the arguments before the High Court. But the High Court did not accept it and has ultimately concluded that this has to be quashed. Why? That is because we will look into a couple of reasons now. What are these reasons? The first is with respect to Article 35. Article 35 bars states from legislating on requirement of domicile in employment. How? Let's look at Article 35 of the Indian Constitution. Legislation to give effect to the provisions of this part, notwithstanding anything in this constitution, Parliament shall have, and the legislature of a state shall not have power to make laws with respect to any matters under clause 3 of Article 16. So we have Article 16 of the Indian Constitution. What does it speak about? It speaks about equality of opportunities in the matters of public employment. So what is it speaking about? It is speaking about public employment. What is it speaking about? It is speaking about employment where I would be given a job by the government. So I would be working for the state, I would be working for the government. So it is public employment. But in this particular case, it is private employment. So how can you equate public employment with private employment? Private employment is where I as an individual, I as a person, I as an organization, I as a company would be coming up with an organization. I would want to build an organization, provide opportunities to the people, and I also have an agenda to make profits as well. So I would be able to decide what will be the skill set, who are the people I'll be employing. So irrespective of who the person is, whether he is from a particular state or from a different state, all that I want as a company and an organization is that this particular person has a particular skill set. If that person is meeting the skill set, why not employ him? So you are violating the company's organizational skill set. Able to decide everything. Why is the state interfering in the private employment? So the state would be able to decide and come up with the laws only with respect to the public employment and not with respect to the private employment. They can make rules and regulations, but then this is a great violation because it is also attached to 16 of 3. What does 16 of 3 says? 16 of 3 says we have something called as the local laws. Let's say, for example, if a person, let's say a citizen of India, he can go there any part of India and ultimately seek for an employment. If there is a law which specifies that only so and so person from a so and so region will have to get employment in a specific region, then it is only the parliament which should be able to make the laws. For example, let's say I am in the state of Karnataka. So in the state of Karnataka, if let's say the government is planning to say that only people who have been residing in the state of Karnataka, or for example, we also have 371J which is to do with Hyderabad Karnataka region. For roles which are meant for Hyderabad Karnataka region, people from other region would not get recruited that particular laws. These are also called as mulk laws as well. Why? That is because there is a specific region. In this specific region, there can also be a specific culture as well. There can also be people who would have acclimatized to the culture of that particular part. So as a result, these people would know the culture of that particular part, and it is why we are call it as mulk laws, land laws and local laws. So they would be recruited for that particular role in that specific region. And who would be able to make the laws in this case? It is the parliament. So if you are speaking about the mulk laws, if you are speaking about a specific region and the employment opportunities, the state cannot make the laws because that has been explicitly mentioned in Article 16 of 3. Nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or appointment to an office under the government or any local or authority within a state or union territory. So who will decide it? It is the parliament. Why is the state government legislating about it? Article 35 of the Indian Constitution even makes an explicit mention about it. Legislation to give effect to the provisions of this part. Parliament shall have, legislature of a state shall not have. So the legislature of a state, Haryana government, it is the legislature. It does not have the power to make laws with respect to 16 of 3. So when it does not have the power, this entire exercise of coming up with the so-called domicile law, local law, endorsing a particular fact that the person from a resident of Haryana would only be able to get the job is a violation. When you do not have the power to legislate in the first place, how can you make a law? That is where the High Court has said that you do not have the power to make the laws and only Parliament has the power to make the laws. And as a result, we are quashing this particular legislation because this also means that the employer will not be able to employ whosoever he wants to, and you are restricting his rights as well, said the Haryana High Court, and has ultimately quashed this legislation. What are the other arguments brought about by the Haryana High Court? The Haryana High Court also said that this is a discrimination against an individual not belonging to the state. We have the preamble of the Indian Constitution. The preamble of the Indian Constitution basically speaks about the fraternity. What is fraternity? It is about brotherhood. So when we speak about brotherhood, it is the brotherhood of the entire country and of all citizens of the country. When I'm speaking about the bonhomie, acquaintance, and if I'm speaking about the relationship and the friendship and the kinship that I'm creating, it is for the entire country. When you are coming up with such laws which says that only local residents will have to be given employment opportunities, this idea of fraternity and brotherhood is ultimately getting violated. Article 14 of the Indian Constitution is getting violated. There is no intelligible differentia. There is no clear-cut classification that you have created, and this classification that you have also created is not permitted by the Constitution because it is violating the fraternity, the brotherhood, the individuality of our country, and as a result, this particular issue is also a violation of Article 14 of the Indian Constitution, and we are quashing this legislation, says the Haryana High Court. Then what we have is the violation of freedom guaranteed under Article 19. When we speak about Article 19 of the Indian Constitution, what we have to focus is on Article 19 of 1 of D and Article 19 of 1 of G. What does Article 19 of 1 of D speak about? It speaks about to move freely throughout the territory of India. I am a person who is, let's say, domiciled in the state of Karnataka. So now I wish to move to the state of Maharashtra, or I want to move to Delhi, or I want to move to Uttar Pradesh. When the Constitution guarantees me this right to move to any part of the country, why is the state restricting this? Why is the state of Haryana restricting me? And this is ultimately violating to move freely throughout the territory of India. Even if there are restrictions, for example, in the Union Territory of Andaman, there are suitable restrictions. There is no such restrictions in the state of Haryana. When there are no such restrictions that are imposed, why is the state restricting me to go and open up my window of opportunities in another state? And added to it, the practice of any profession to carry out any occupation, trade and business. I would be able to seek the employment in any state of India that I wish to. So in this particular case, there is a company which is wanting to come up and open and practice a profession. There is an individual who is looking for an opportunity. So there are two people. One is an employer, the other happens to be an employee. The employer is wanting to recruit people so that he is able to generate the profits. The employer is wanting to work so that he can make a livelihood out of it. By you creating a new nuance argument in favor of the local residents, all these constitutional arguments are getting violated. 19 of 1 of D is getting violated because I'm not able to move freely. 19 of 1 of G is getting violated because I'm not able to sustain a livelihood, make a livelihood out of it, because you're creating obstacles and number of impediments. If these are the impediments that are present, how will I make a livelihood of it? And this is violating the practice of profession. So 19 of 1 of G is also getting violated, says the Haryana High Court. Then this is a violation of constitutional morality. Originally, there was no such thing envisaged by the constitutional makers. Since you are violating the brotherhood, this is violating the constitutional morality of the constitution, and you have also created Inspector Raj of the state. How? We have created a portal. In this particular portal, what are you supposed to do? You are supposed to make sure that there are only those people from the state of Haryana who are recruited, and periodically you have to keep updating data. I am a company who's wanting to follow corporate governance structure, but this has become a license Raj structure. Why? That is because I have to keep uploading documents after documents. There can be an inspector who comes, a designated officer who comes up, and he immediately says that you're not meeting the intended objective of this particular legislation. I may have to pay bribe to that particular person. There are n number of papers that I have to meet. This is nothing but Inspector Raj, license Raj, and this is again a violation of the so-called liberal movement that we have created for the Indian economy. And as a result, this does not meet any of the agendas that have been established, and as a result, we are quashing all of this, says the Haryana High Court. So this could also create and rake up couple of other problems as well. As we see, we have a number of other states who have also come up with similar such patterns. In Haryana, what we have is 75% reservation, which we just discussed. Andhra Pradesh in 2019 also came up with such issue, 75% reservation for the local industry factories. Karnataka also come up with a draft where 100% reservation for locals in the blue collar jobs. Rajasthan, 5% reservation to certain communities, 13% reservation to certain communities in the state of Maharashtra. So if one state starts, every other will state start such a practice, and ultimately this would create problems such as son of the soil. This would ultimately create problems such as parochialism, where I would be restricted to only those people who would speak a specific language, who are the residents of a particular state for a very long period of time, and ultimately it will create parochialism, and thus it will break the very identity of India. India is known for its unity in diversity. We are a country of myriad religions, myriad cultures, myriad practices, and that's the beauty of India. And when we are bisecting this, differentiating people on the basis of the state and the accommodation or the residentship of that person, we are breaking India, and this could possibly lead to issues and concerns in couple of other states as well. So the problem being that this would raise the son of the soil issue and could create internal disturbances with one state creating a law. Similar such states will be creating further laws, and we would not be able to move freely within India, and we would not be able to practice our profession as well. But once we look into this law, what are the reasons for many states coming up with this law? One is because of the vote bank politics. When we speak about parochialism, we have a couple of examples in number of states as well, where they specifically focus on a language. They also focus on some of the issues where it is only restricted to that particular religion. So one happens to be the vote bank politics. The other happens to be the economic stagnation. For example, there is a specific state, as told by Haryana, they are not able to generate enough amount of job opportunities, so there is economic stagnation as well. So in order to provide boost to such people, provide them the employment means and opportunities, livelihood means and mechanisms, this measure has been taken. And in order to retain the state as well, many people will start moving from their state to some other state. In order to retain these individuals, we have seen brain drain from India to number of other countries, for example United States of America, UK, Australia, so on and so forth. So brain drain can also happen if people start moving from one state to another state as well. What would happen? Let's say for example, in this particular case, people start moving from one state to another state. So if job opportunities and livelihood means and mechanisms are present in their state, they would be able to retain the people, and as a result they continue to live in that state. That is another way as to why they've come up with the law, and this will also mean that they would be able to capture on the vote bank, form the government, and continue to come up with more provisions and laws for their state, which is why political parties raking up such issues. It is this that we have to understand with respect to this topic. Now let's look into the next article. This article here is speaking about one of the concepts called as the lookout circular. Let us try and understand what is this topic all about. This is very important from the preliminary examination point of view as well as from the mains examination point of view, polity and governance. So the first important question that we have to understand is, what is this lookout circular? As the very name denotes, you are looking out for a person. Who is this person? We have a person, let's say for example, he's committed a cognizable offense or he's committed an economic offense. The police are trying to investigate and find out where this person is, but he is not there, he is absconded, or for example, even if he is present, all of a sudden he may leave the country. So in order to prevent such a person who's committed a cognizable offense or an economic offense, or to prevent this person from leaving the country, a lookout circular will be issued by the Government of India, by the Ministry of Home Affairs as well as by the banks. So this means when a lookout circular is issued by a certain institution or an organization or a bank, this person when he goes to the airport will not be allowed to leave the country. So a circular will be issued by one of the designated institute. It will be given to the airports, railways, so on and so forth, and this person would not be allowed to leave the country. So who will issue this lookout circular? What we have is the Bureau of Immigration. So the Bureau of Immigration happens to be an Indian government agency working under the Ministry of Home Affairs, responsible for administering immigration related functions such as immigration facilities such as at the seaports, integrated checkposts and airports, and the foreign registration. So because they are the ones, they can issue this lookout circular, and that apart you will also have, let's say for example, permission given to number of institutions, for example CBI, Enforcement Directorate, SFIO and public sector banks. These are the institutions which would also be able to issue the lookout circular. Is this lookout circular something unique to India? Not at all. This lookout circular are also present in couple of other countries as well. For example, in Australia they have something called as departure prohibition order, and the United States maintains a no-fly list as well, and this entire exercise is taken out from the Passports Act of 1967, which allows the central government to suspend invalid passports if found to be necessary in the public interest. As of now, we do have the LOC, which basically means the lookout circular, and this lookout circular is based on the Ministry of Home Affairs February 2021 office memorandum. So they have a memorandum, and according to this memorandum, guidelines will be issued, and these institutions and organizations like CBI, ED, SFIO would be able to issue the lookout circular, and then a person would be prevented from leaving the country. So what is a lookout circular? A lookout circular is a circular which is issued by the Ministry of Home Affairs or any of its institutions, and even a bank as well, so that an individual, if he happens to go to an airport or any of the ports which will help him move outside the country, he is prevented from moving outside the country, which is what is called as a lookout circular. But when we speak about the lookout circular, there are a couple of concerns that are associated with the lookout circular. What are these concerns? Only when they are stopped at the immigration checkpoints. What do I mean by it? Let's say for example, I am a person, I might have committed an economic offense, I might have cheated people, or for example, I might be a person who might have committed a cognizable offense, or there is an apprehension that I might have committed a cognizable offense. They have not yet proved that I have committed a cognizable offense or not, but there is a insight that I might have committed, there is evidence, but it is yet not proved. In that particular case, a lookout circular is issued against me. So what would happen? In case I am planning to move outside the country, these officers at the airport would not allow me, and they would ultimately restrict me. So what would happen when a LOC, that is the lookout circular, is immediately issued? I might be arrested, or I might not be arrested as well, which means I am restrained from moving outside the country. If I am arrested, I will be given to one of the designated state institutions, whosoever is investigating the case. It can be the local police officers, it can be the CBI as well, it can be the NIA as well, it can be the SFIO, it can be the enforcement directorate. Whichever is the institution which is investigating it, they would be able to ultimately take me under their custody. So I can be arrested or I can just be detained as well. But what happens in most of the situations, in case there is a lookout circular, I should be given an opportunity, I should be heard as well. That is what is the principles of natural justice. One of the principles of natural justice happens to be that every other party who is involved in a litigation should be heard. If I am not heard, that is ultimately violating my principles. So what would happen? I am not given an intimation that I have committed so and so crime. I might not know about it. It might be a cognizable offense, it might be a non-cognizable offense. Non-cognizable offense, it does not matter, but in this case it is a cognizable offense, or I might have committed an economic offense which I might not know. There is an insight that I might committed it, but I do not know about it. When I do not know about it, I should be given a prior intimation as well that you have committed so and so, that you are not supposed to leave the country. Such a notification would not be given to me, and all of a sudden I go to the airport and then they obviously prevent me from leaving the country. So does it not violate the liberty to move outside the country? And at the same time, I am in an airport, I am restrained, I am arrested in the airport, which could have been done earlier with notice. I would have gone to the police station, I would have, on a voluntary basis, I would have gone there. But since you're doing it on instantaneously in the airport, is it not violating my reputation? And reputation is one of the fundamental rights as well. Since it is violating my reputation, this is harming me as an individual. So you could have you are stopping me at the immigration checkpoints. First, you could have intimated me prior to it. You did not intimate, and you should have asked me what are the charges that are put on me. That is again not explained, which is again the violation of principles of natural justice, and there is no obligation to inform the individual that an LOC is open. So when a case is against me, that you are stopping me from moving outside of country, a lookout circular has been issued, this is yet not given to me as well. Or let's say for example, there is a crime. In this particular crime, there is an accused. He might be a person who has committed a crime, but then there might be a person who is a witness to it. The witness is nowhere related to this particular crime, but then the LOCs are also issued against the witnesses primarily because of an insight or because of a perception and a viewpoint that this person might also be involved in it. There is no concurrent evidence in the first place. They do not have documental evidence. There is no primary evidence in this particular case. No person has said that this witness is involved in the crime, but despite he being only the witness, there is an insight that this person might have committed. So even if my role is not there, there are these officers who are preventing me from leaving the country. So witnesses who are not accused of the crime are also prevented. So LOCs are also issued against them, and they are often forced to rush to the court to identify the reasons for issuing an LOC and then go through the arduous process of having it cancelled. Sometimes I do not know why am I being issued with the LOC. I myself don't know why is that the authorities are stopping me. So let's say for example, I have an event which I have to attend in United States of America. I'm going to United States of America, but all of a sudden they stop me from that. Or I have a business meet in United States of America, they stop me from going to United States of America, and even I do not know. So immediately I have to go to the coach, ask what is this LOC all about. I don't even know what that LOC is. I have to hire advocates as well. I have to pay exorbitant fees to these advocates as well. My reputation is at stake, and I have to knock the doors of the court as well. So is it not violating my reputation? Is it not violating some of the people's reputation? Is it not investing huge amount of money on the advocates, legal expenses, and ultimately even if I'm going to United States of America, that event is also got cancelled because I'm not able to leave on time, and my business meetings are also cancelled, and this is also hitting me economically as well. And the OM, that is the office memorandum, gives no indication as to when banks can call for an LOC to be issued. So banks of late are also making use of these these circulars primarily because they do not want an individual to live. So what is the office memorandum speaking about? It speaks about the public cost. It also speaks about the country as well. So in case there is an individual who has taken a lot of loans, and if this person has an NPA and if is planning to abscond, fair and fine that the bank comes up with it. But in other cases, banks are also misusing it. How? Let me give you an example. Let's say, for example, there is a person, he has taken about 100 crores of loan from a bank. So there is a fear and an apprehension that this person may be evading the system and he will go outside the country and may not pay the loan back. When you have given so much of loans, you should also trust that person. But just because you fear that this person might evade the system and move outside the country, you are stopping that person from moving outside the country. This ultimately means that there is no public interest but only bank's interest. In fact, the courts in India have also criticized the bank. Despite criticism, banks continue to use this LOC, lookout circulars. So this ultimately means that there are concerns that are associated with the lookout circulars, and as a result, what we need to have is unambiguous, not so vague, but clear-cut guidelines and the structure that has to be expressed in the office memorandum with respect to the Ministry of Home Affairs is what is this article all about. Now let's look into the next article. This article says state of the economy temper the euphoria. So the article in this particular case speaks about one of the annual reports. So we have a semi-annual report called as the World Economic Outlook. So remember, from the preliminary examination point of view, we have something called as the World Economic Outlook. Who is it released by? It is released by the International Monetary Fund. So the World Economic Outlook is released by the International Monetary Fund. It has revised its project GDP growth for India for 2023-24 to 6.3%, up from the earlier 6.1%. So earlier it was projected to grow at 6.1%. Now it is growing at 6.3%. And added to it, what this article also says is that when it comes to the world economy, it is not growing that much. When it comes to the Chinese economy, it is also seeing a depreciation as well. So we are seeing a greener light, a limelight right now, because our economy is increasing, but the world's economy and Chinese economy is also depreciating or decreasing. So this means that we have something good happening on one side, but we should not be too happy. Why? That is because there are other issues and concerns that are associated with respect to India. What are these issues and concerns? One, we have issues on the employment front. We have number of people who are not employed. The quality of employment is yet to be fructified, and the persistence of inflation of the essential food items is affecting the poor. So we might have the economy growing, but we still have the unemployment crisis. The quality of employment provided to the people is also low. For example, people who are graduates are also applying to the peon post in the state of Uttar Pradesh, and number of people are also applying for the basic government jobs as well. So the quality of jobs that we are creating is also not good for the graduates, and the inflation is persisting, which will ultimately hit the poor sections of the society. So what should we focus on? We should focus on all these aspects. Yes, the economy is growing, but we have to focus on these aspects as well. Then when it comes to China, India's dependence on Chinese imports of manufacturers seems structural and not easily corrected by changes in the relative prices. So despite we trying to impose certain restrictions with respect to China, we continue to rely on China for all kinds of imports. In fact, our manufacturing premises and the growth of the manufacturing sector has also reduced as well. The mirror image of rising China's imports is a steady decline for the industrial growth rate from 13.1% in the 2015 and 16 to negative 3.5% per year in 2019 and 20. Because there has been exponential rise of the imports from the China, what it also means is that our manufacturing is not increasing over a period of time, because most of it is being imported from China. So we have to work on the manufacturing front as well. It is the service sector which is taking us more than 65% of the economy is based on the service sector. This has to be changed. If this has to be changed, the manufacturing sector will also have to contribute equally as well. So when imports are increasing from China, how can you fight China? When it comes to economic activities, you would not be able to do so. So work on that front. From 2011 and 12 to 2021-22, gross fixed capital information to GDP ratio at current prices declined steadily from 34.3% to 28.9%, an unprecedented fall in the post-independent India, and its public sector share has remained constant at 8%. Net foreign direct investments to current GDP ratio fell from 3.6% in 2008, 2.4% in 2022. These are the other areas that we have to focus on. One is with respect to the capital formation, how much of capital that we are increasing, capital investments we are making, foreign direct investments, that is the foreign companies and its organizations coming and investing in India. This is also dropping, so this has to increase as well. The value of India's HDI index moderated from 0.645 in 2018 to 0.633 in 2021, and its global rank went down by 1 rank during 2015-21, meaning that other countries have performed better than India. So if we are happy that the Indian economy is going at about 6.3%, it is good. We can be happy for a very brief period of time, but we have to work on all these areas, says the author. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says India targets 40 billion in technical textiles. What are these technical textiles? Technical textiles are defined as textile materials and products used primarily for their technical performance and functional properties rather than aesthetic or the decorative characteristics. What are the other terms used for technical textiles? It includes industrial textiles, functional textiles, performance textiles, engineering textiles, invisible textiles and high-tech textiles. These technical textiles are used individually or as a component part of another product. These technical textiles are used individually to satisfy specific functions such as fire retardant fabric. Let's say for example, we have a fire that is caught up in a particular building, so you would be employing people who go and fight that particular fire in that industry, so they have to wear a different kind of a material. That material which is different from normal clothing, which is fire retardant fabric, is an example of technical textiles. For uniforms of firemen and coated fabric to be used as awnings as a component or part of another product, they are used to enhance the strength, performance or other functional properties of the product. So firemen will be using cloth is one such example of technical textiles. There are similar such examples as well, which includes in agrotech, meditech, mobile tech, on tech, cloth tech, geotech, home tech, indoor tech, sport tech, pro tech, pack tech. For example, when it comes to sportswear, they have a different kind of clothing, and when it comes to packaging industry, they have a different kind of clothing. Or for people who are engaged in waste disposal, they have a different types of clothing. So all these different types of clothing that we have is called as the technical textiles. So what we have is we have embarked on a journey to improvise on the technical textiles, and the government of India has come up with the National Technical Textile Mission, and it has unveiled 3 years ago, has been extended till 2026, says the author. So this article says that the government allocated 1000 crore under the mission for research and development, and so far 126 projects with a total value of 371 crore have been approved, says this article. Now let's look into the next article. This article is going back to the technical textiles, we have some of the advantages and the concerns. So these technical textiles have contributed immensely to the product improvement, public safety, cost reduction and durability of the infrastructure projects. And one of the major factors affecting the growth of technical textiles is the lack of quality manpower, specially educated, trained engineers and professionals, and highly skilled workmen, both for manufacturing and application area of technical textiles. These are some of the concerns that are associated with this particular industry. Now let's look into the next article. This article says uncertain future in the sea of poppies. So this article here is speaking about growing of opium in number of states in, for example, Rajasthan, Madhya Pradesh, Chhattisgarh, so on and so forth. So in India, there are about 1 lakh farmers across 22 districts in Madhya Pradesh, Rajasthan, Uttar Pradesh, with a license to cultivate opium. Majority of them are from 3 districts, that is along the borders of Madhya Pradesh and Rajasthan, which includes Mandsaur, Nisach and Chittorgarh, which are very important from your preliminary examination point of view, and these districts contribute to about 80% of India's opium. There are 2 types of narcotic materials that can be produced from the opium poppy. One happens to be the opium gum, which is the latex. The other happens to be concentrate of the poppy straw, which is called as the CPS. Why are they allowed to grow the opium? That is because when it comes to opium, it contains morphine, which is known to relieve the chronic pain and is used mostly by the pharmaceutical industries to produce the medicines. That is why they are allowed to grow the opium. They would be given the licenses as well. They should be able to update what is the quantity of the opium that they have produced, and ultimately this should be given to the government of India. So the gum is procured solely by the Central Bureau of Narcotics, which functions under the Union Finance Ministry. Because this substance happens to be addictive, it can cause mental clouding and hallucination. Opium production is highly regulated in India under the NDPS Act. So from the preliminary examination point of view, remember, we have something called as the opium gum. This is procured by the Central Bureau of Narcotics, functions under the Ministry of Union Finance Ministry. And this will be regulated by the central government, is what is this article all about. If you're liking these initiatives, please to hit on the like button, like the video, share it with your fellow aspirants as well, and subscribe to our YouTube channel. So this is it for today. Thank you for watching. All the best.